Good afternoon. Right at afternoon, everyone. I'm Gantt-Sorenson, and I am with Haynsworth Sinkler Boyd Law Firm, and looking forward to talking to you all today about all the current laws you need to know to comply with those laws as they pertain to pregnant employees and nursing mothers. All right, so definitely ask any questions you have as we go along, and also if you have anything you want to put in the chat box, do that. But before I get started, I just wanted to tell you, we started to talk about this in the spring, and I decided I would cover FMLA and ADA and the PWFA and the Pump Act. And what ended up happening is I got so many awesome questions about stuff before we even got to the PWFA and the Pump Act that those attendees who were really just needing to hear about that were sort of like, they were pretty frustrated. So since that time, I have actually been trying to get back to you and have this conversation. So today is sort of a conversation that's a continuation of that, but with the good news is we now have the Department of Labor guidance in addition to what we knew back when I was trying to tackle this in the spring to also talk about it. And it has shed some light on specifically the Pump Act. So I'm excited to be here. I have the questions box open. Brittany is going to be, with marketing department, is going to be monitoring the chat and the question box to make sure I'm answering what you have that comes up. Katie Busbee was going to join me for this, and so if you signed up for it, you were wondering where Katie is, and she had something come up, so I'm going to handle this today, and you're going to hear from her next month, and she's got a really great top 10 things you're going to need to know that are very current right now. So, and then we've got another webinar that we're doing in December with Denny Major, and I think Denny's going to be talking about the new DOL rules as well as some non-compete stuff. So that's what we have lined up for the rest of this year. We'll give y'all a break in December from us, but we're always available to you for any questions that you have. So these are the laws I'm going to talk about today. And obviously, as I indicated to you before, I'm really going to concentrate more on those associated with pregnancy and nursing. I'm going to talk about the federal law as well as the state law. South Carolina's is going to be the law I cover rather than other states. The federal law applies to all states. So next slide. Next slide. All right, so here are the laws that I'm really going to talk about the most today. The Pregnancy Workplace Fairness Act, PWFA, the Pregnancy Non-Discrimination Act, the Pregnancy Accommodations Act, the South Carolina Lactation Support Act, and the ADA. What is missing from this is the Pump Act, and I didn't catch that when I proofread this thing. I'm also going to be talking about the Pump Act. So I'm going to talk about them, and I'm going to group them, the federal state laws, as they apply to specific issues. So first we'll be talking about the PWFA and the South Carolina Pregnancy Accommodations Act and the ADA. And then the second section, I'm going to cover the Pump Act and the South Carolina Lactation Support Act. Next slide. All right, so the PWFA, and most of y'all know this, went into effect June 27, 2023. And if you had to describe it, to someone that says, what is the PWFA? You would say the PWFA is applying the American with Disabilities Act requirements to pregnant and postpartum employees. That's how you'd categorize it. Now, the truth is the ADA is different than the PWFA, but the concept of the PWFA is the concept of the ADA as it applies to all disabled employees. Of course, pregnancy is not a disability, so this PWFA law also applies to pregnant employees who are not disabled but are pregnant. What, in summary, the PWFA requires is that pregnant, postpartum, or lactating employees, so understand this also applies to nursing mothers, lactating employees, reasonable accommodations absent the undue hardship. And, you know, those can arise in pregnancy from actually just, you know, the giving of the birth. Doesn't have to be a disability or a medical condition. Giving birth is protected by the PWFA, and leave to recover to the PWFA. Also, any sort of medical conditions that can be affected by pregnancy before and after. Someone just asked, does this include miscarriage? Yes. Miscarriage is a medical condition that can arise from being pregnant. So yes, great question. Thank you. Postpartum, depression, medical conditions associated with postpartum, medical conditions because of giving birth that need more than whatever the period of time your policy allows for leave. You know, I can keep probably thinking about things. You know, if this isn't protected by FMLA leave in your workplace, if it is FMLA leave, then that's 12 weeks. But even after that, you know, if the conditions for which the conditions that were caused by the pregnancy and giving birth extend beyond 12 weeks, then, you know, this applies. And also lactating. And so, you know, one of my law partners ended up having a medical condition associated with lactating over a year after she gave birth. And so that would apply, right? And, you know, so you got to think broadly about what applies here. And medical always includes psychological or mental. This act applies to employers with 15 or more employees, and then to all government employers. Next slide. So who is qualified to avail themselves of the PWFA? It's any employee. There's not a waiting period for this to apply like you expect for FMLA or even some other laws. There's no waiting period. And it's the employee is pregnant and there is an inability to perform an essential function of the job. Here's the caveat: for a temporary period. Y'all all know that under the ADA, essential function of the job is current. Somebody is asking for an accommodation and they can't perform an essential function of the job, and that's right now, then, you know, this is not a qualified individual with a disability under the ADA. Under the PWFA, essential function is defined as can't do now, but could be performed in the near future. And also could be performed by the accommodation, right? So in this situation, if there's a way for someone else, is the way I'm going to say this, to come and do this, then that is an accommodation that has to be considered, even though it is an essential function of the job. So that is pretty comprehensive, and an application is different than the ADA. All right, next slide. The PWFA, as well as the South Carolina Pregnancy Accommodations Act, lists a number of accommodations that the drafters of this law, of this act, believe are reasonable. Now, here's my point on reasonableness of accommodation. If either Congress or our state legislature listed accommodations, we need to work pretty hard to spell out why they are not workable, right? So you have to entertain any accommodation that an employee requests. And what I'm saying here is that in regards to specific accommodations listed by either Congress in the PWFA or South Carolina's legislature in the Pregnancy Accommodations Act, I think you need to go the extra mile to explain why this is not reasonable. You're always going to have to explain it's reasonable, but I just want it to be able to be something that we can explain more. If we can't, we can't, okay? That doesn't mean it's a deal killer, right, to say no. It doesn't mean that I'm automatically going to say, oh, we can't do it because it's in the list and this isn't as much of a unreasonable accommodation cell reason that you're giving, as opposed to others. I mean, in truth of the matter, that's, a nuance that I'm just throwing out for you to think about and how you approach the accommodations that are specifically listed. An unreasonable accommodation is an unreasonable accommodation. So I don't want to suggest to you that you have to follow it just because it's one that's listed. I'm just saying it's going to be looked at more stringently, in my opinion, if it's challenged by the EOC or I'm getting some good questions down there. And I'm like the commercial that's the dog goes squirrel. The chats pop up, and apparently I want to read what's coming up. So please forgive me if I come off my discussion a little bit. But anyway, just remember the EOC, who's the enforcer of the PWFA, and also the first adjudicator as to whether or not we violated it, is going to look at these more stringently. But that doesn't mean we can't show how they're unreasonable, just that I'm alerting you to it. So I think I've gotten 2 questions, and I'm going to try to answer these as these come up, because I think that goes better, and they're in the chat. So let me just pop them up. So one question is, how do we define near future or temporary? What is reasonable? I think that is a fabulous, fabulous question. And we had this question, Katie and I did this summer for a client. This was a client who needed someone to be able to do an essential function of the job for at least the length of the pregnancy, and also probably the length of the time out, right? So, well, the time out's protected for this employer because of FMLA. But as far as a PWFA accommodation, this was something that the employer did not think was reasonable for a 40-week time period. It was only reasonable for the employer for about 2 or 3 weeks. And it was not a function that could be accommodated by having someone else do it in the near future. And so I cannot stand here and give you advice not knowing your specific facts. And this, like the ADA, is a case-by-case basis, and all the facts work together to mean different things. And but I will say that was a decision that the employer made, was we couldn't accommodate this. It has not been challenged, right? So the PWFA is new, and there's not been any EOC charge filed yet on this. Employees have 300 days in our state to file an EOC charge or a charge with SHAC if they believe they've been treated unfairly under this law. So we don't know what this law, how the EOC will interpret what I just outlined, nor do we know how the courts will. That's what's tough about these laws. But we said they were able to provide what we believed was enough explanation to justify the decision that the accommodation could not be granted for the length of the pregnancy. So the next question, I think what I want to be sure I've answered that as far as what's reasonable. So that's going to depend on your specific job and if you can accommodate it, and if you can staff it with other folks and what you do for other folks. Because the PWFA and the ADA always require us to do something we otherwise don't do, always require us to do something otherwise that we don't have written in our policies. Always require us to consider and or offer something that we ordinarily wouldn't offer to anyone else. So the next question was, is this only applicable to pregnant mommies to be? What about people who are going through IVF in an attempt to get pregnant? So I think that's a very, very interesting question. And I think while there might be some state law applicable to IVF situations and what laws they fall under, I think I would call this more an ADA issue, and I would call it more medical conditions that are temporarily serious health conditions or that meet that level, which is a pretty broadly defined thing, under the FMLA/ADA. I'm not entirely sure if getting pregnant is something, and any medical conditions associated with getting pregnant are going to be protected under any of the acts that I'm talking about. I think that's a fabulous, fabulous question. And I think we'll have to keep our ears peeled to the ground to see if there's anything that's going to advise us more on that. Right now, there is nothing that suggests it falls through it that I'm aware of, that includes it. And then this question says, but what about mommies who adopt? Mommies who adopt are protected under the FMLA, just as a mommy who gives birth. Mommies are only protected under the FMLA or the PWFA or the Pump Act if they are themselves experiencing whatever it is that requires them to seek coverage under the PWFA or the Pump Act. And so that's going to mean that this is an employee who's developed some sort of medical or psychological condition on the basis of being pregnant. Now, I could foresee that the PWFA would protect a mommy who adopts from postpartum depression. I could see where that would be possible. Anytime you have any employee who is contending they are just physically unable to do something due to either mental or physical stress, because another one would be exhaustion for lack of sleep, right? That's another one that a mommy who adopts could have just as easily as a mommy who gives birth. You need to get those documented by the provider, and what the employee can and cannot do, and anticipated return, all that. That's what I want you to do. That's my recommendation. And that's true of any sort of accommodation that anybody asks for. I want you to treat all your employees the same. Don't do this with just your pregnant employees, certainly. That would be a big no-no. But after a mommy gives you the medical documentation that's adopted that shows that she is suffering from a serious health condition associated with, postpartum, or she's suffering from just some sort of medical or mental condition postpartum, whether it be just depression, which is a serious health condition, or lack of sleep, which may or may not be, right? I think you have to protect it if they can provide medical documentation for us. That's a great question. Next slide. All right, employer compliance. Y'all know what you can't do, right? You know that you can't hold this against them if they ask for leave. They can't be retaliated against if they're going to need leave. They can't be retaliated against if they're going to need more leave than what originally is planned or what your policy allows, or FMLA allows, right? Now, that is actually hard, not hard for my HR folks, not hard for them, and really not hard for all employers. But I do know that that continues to be sometimes an issue that some of y'all face in trying to convince your decision makers or your managers that this is illegal. That continues to be a thing. This continues to be a thing where pregnant women, there are assumptions made about pregnant women in the workplace. And so I know y'all are good advocates there. Another one is that you cannot require an employee to accept an accommodation that they don't want. You do have to engage in the interactive process. And if they are unable to work because of the accommodation, you have to consider leave as an accommodation. And that would mean job protected leave, even if they're not protected under the FMLA, because that is something that the ADA requires. And remember, the ADA requires that you do leave as an accommodation and recommends that it be protected from the job absent undue hardship. And so that would be something that you would want to apply here, especially in light of the fact that the time out from work would probably be temporary compared to some chronic condition that is permanent. Always document the discussions you have with your employees about accommodations and any sort of decisions that you arrive at, or if there's a determination that you cannot accommodate. Do that with any employee who's asking for accommodation, including the PWFA employee, the pregnant employee. And you need to do this with a witness in the room, and do it like you would, like I'm always saying, we need to do our discipline documentation, because this is something that while you're talking and the employee's talking back and forth, somebody else needs to be taking notes. And then the witness who did that needs to date and sign them. And if you reach an agreement with the employee about, okay, this is how we're going to accommodate your job, I want that on a separate form to be signed by you and the employee and the witness. If the employee refuses to sign, which would be troubling, But if the employee refuses to sign because maybe they didn't like the accommodation, but they're agreeing to it, then the witness says what they would do, just like they do with the discipline, which is the employee and the employer agreed to this accommodation. The employee was preferring a different accommodation, and it was explained to her why this couldn't be granted. And therefore the employee agreed to this accommodation, but refused to sign because she wanted the original accommodation. So that's what your witness would write and date and sign. That's the documentation I'm talking about. Next slide. Medical needs. We're into the South Carolina Pregnancy Accommodation Act. The law is exactly the same as the PWFA, so I'm not going to cover any of that. The law does specifically require that employers treat pregnant workers similar in their ability to work or inability to work. What that means is if we grant light duty for other workers, even if it's just workers' comp workers, right? A lot of companies have light duty policies for workers' comp. And that's because their insurance company is sort of insisting on that, so that, this is Chris's opinion, so that they can save a little money on these workers' comp wages. And it could also be because employers want to get an employee back to work and have them working even with light duty. So it could be lots of reasons. I'm just jaded and think it's usually because I do know the insurance companies, your workers' comp insurance companies, pressure you to return people to work. And they may say it's in relation to, it's going to increase the premium, or it's best to get them back to work. Don't assume just because your comp carrier is suggesting you get somebody back to work that it's going to comply with the other laws, or it's not going to be something that can be considered later in other laws. For example, the PWFA. If we do light duty for comp, we're going to have to consider it for pregnant workers. Nursing mothers is also addressed in the South Carolina Accommodations Act, and it tracks the South Carolina Lactation Support Act 1 year after childbirth, reasonable time to express throughout the day, private place with a lot, unpaid break or PTO, depending on how the employer handles other breaks. I want to table that because the PUMP Act preempts South Carolina's Pregnancy and Accommodation Act on this, as well as the Lactation Support Act, and it's a lot more comprehensive. Next slide. So the next slide is the accommodations listed by the South Carolina Act, just some of them. There's a ton of them. And again, same position applies here. We want to really be able to articulate why it's unreasonable if we're not going to grant these. All right, next slide. Same thing here. You can't make somebody take an accommodation they don't want to take. What do you do if someone wants a certain accommodation, you can't grant it, you've explained to them why it's unreasonable, and it would, and I'd recommend you think in terms of undue hardship when you're talking about why it's unreasonable. You'd be able to give specific, tangible reasons. And then you offer another accommodation that you can accommodate, and the employee does not want it. What do you do? Well, leave as an accommodation can be something you consider as an accommodation here. If they're protected by FMLA, you want to go ahead and start that. Remember, you need medical documentation for all that. So this is a little dicey, and I recommend you get some help with that. Also, don't make assumptions that your pregnant employee does not, thanks, Brittany, your pregnant employee is not able to do things. I do see that happen a lot. And so when I think about in terms of opportunities for individuals, and stuff. So somebody is, for instance, wanting to attend a conference training or some sort of client visit, and they're going to be advanced in their pregnancy, and you don't offer it to them. I still hear even, women execs who are trying to be supportive and helpful say, well, maybe so-and-so doesn't want to do that because of, they've got young kids, or, they're pregnant, or they're whatever. And that's against the law, right? We always ask the employee, hey, is this something you want? And if the employee thinks it's something they can't do, we've got to let them tell us that. Otherwise, whatever opportunities are out there, they need to be extended. They don't need to be denied opportunities on the basis of their pregnancy unless they just don't want to do it. All right, next slide. And we have some more questions. Is there a duration of tenure that must be achieved before coverage is available? And if you're talking about the PWFA, no. If you're talking about the PUMP Act, no. There's no amount of time that somebody needs to be working for us before these laws apply. All right. Pregnancy-related conditions. There are some of those that are specifically mentioned in the ADA, and here are some of them. And then, so walking, standing, lifting, not new. Remember that the ADA has requirements around major bodily functions. And so here are some that we've listed that could be implicated in pregnancy. Next slide. Examples of pregnancy-related impairments under the ADA that, of course, are also going to be in the PWFA. And you can see some of these here. These are all pretty common things. And some of the others in the chat box have been brought up too, like miscarriage. So postpartum depression we've talked about, inability to sleep, and that, and sleep exhaustion. Next slide. Some examples of reasonable accommodations. We've talked about most of these. Bed red to telework. Bed red leave as an accommodation if they can't telework. We won't get into all the parameters around teleworking, but there's some P's and Q's there that you got to follow. Redistributing non-essential functions, and PDFA, that would also include essential functions if you're able to do that. Like duty. Modify equipment, right? Under the ADA, that's another requirement. Is there a way to modify? Is there a way to relax your policies? Nobody's allowed a water bottle at the machine. Well, let's let this person have a water bottle at the machine. They're pregnant. Or no food. Well, what about some crackers? What about some food? Can we extend this? Somebody has to go to the restroom a lot more. That happens very, very many times in pregnancy. They got to be allowed to go. It may be frustrating for production, but your boots on the ground lead employees are going to have to accommodate that. Next slide. All right. The PWFA, ADA, and SCPAA differences and similarities. We'll start with similarities. Reasonable accommodation, change the way things are ordinarily done, right? So if you find yourself saying, or your manager is more likely, or decision makers, that's not the way we do that here. That's your first clue that we need to make sure that doesn't matter. Please understand that that is what these laws are meant to protect, is for us to come up with some other way to do it for this employee on a case-by-case basis as it's needed. Interactive process, we talked about that, what that looks like and how that should be documented. And then undue hardship. Down here, it says significant difficulty or expense. I would encourage you to understand that under the ADA, this is just an abbreviation. It's much more detailed than that. There are specific definitions of what is considered undue hardship for job modification and separate ones for leave as an accommodation. And I think I have at least one of those. They're similar, so one of them in these slides. I doubt we get all the way to it, but I've got some basic stuff in these slides for you to refer back to. And expense, by the way, is always sliding scale based upon the size of your company and the profit of your company. How lean are you, these sorts of things. And if you are, bringing in temps to do certain things, why can't you do it here? All those types of things. It's many factors. Next slide. Someone asked, if you do a light duty position, can you modify compensation to match the position? It's a very, very good question. If this is someone who's protected under FMLA, no, because remember, FMLA has these rules about switching me to an alternative position, but same rate of pay. If this is not protected under the FMLA, the PWFA does not have any pay rules. So as long as you would do this for every other employee, workers' comp included, if you would, when you had them do light duty work, pay them a different rate, then you can do it for the pregnant employee under the ADA, 7 days advance written notice for this decrease in pay. And before then, and that's South Carolina Payment of Wage Act, y'all. Before then, we need to make sure that we've agreed on this accommodation. If she doesn't want it, then we can't go this route. Also, there is paid leave. Like if these folks have paid leave or short-term disability, and they're going, let's say, part-time, and they would therefore qualify for some short-term disability payments, we need to be submitting those to our disability carrier. And depending on what your period of short-term disability time is, you need to then turn around and submit it to the LTD carrier. And then you can true up, that, because typically those are like 50 to 60% of what the employee is earning. You can true up that with what they're otherwise receiving under this job. If you're putting them in a lower rate position, you need to pay them what that lower rate position is. You don't need to just moderate it, because we can also apply STD, right? But if they're going to be sent out on leave, or you know, this isn't going to be anywhere near their normal income, and nor will it cover the STD is going to be a percentage of, you know, their current position. It's an alternative position. You know, I don't know. That's going to depend on your carrier's plan, right? Then you can also use PTO that they have if the there's any to true that up to them 100% their normal wage. So that's something you have to think about. All right. Substantially limit. We've already talked about what all this means. I think y'all understand what a qualified individual means. I will mention for the PWFA purposes, that is somebody who is unable to do the essential function of the job in the near future. And I want to stop here and go a little slower in light of that scenario I gave you earlier. And certainly I was aware this is here, meaning generally 40 weeks. So the proposed regulations that have been put out by the Department of Labor in regards to the PWFA, they have not become final rules yet. Those say near future to us means 40 weeks. So what about my employer who just was adamant they're not going to be able to accommodate this in 3 weeks? We came up with the best reasons for it, and we just hope it's going to stick, right? But you can see that the way the PWFA defines a qualified individual is someone who cannot do the essential functions of the job for the next 40 weeks. So keep that in mind and really challenge yourself. Is this something that we can cover for them for the next 40 weeks? And if we can't, we got to be able to articulate legitimate reasons, and then, you know, that'll be something that should be protected, but can't make any guarantees. All right, next slide. Okay, so Katie, I don't know if that's Katie. It says Katie Busbee. Awesome. So Katie has got my back over here, and she's researching some things for me as we talk today, and y'all's questions come up. And y'all look, Katie said, new regulations for PWFA says that applies to those struggling with infertility or doing infertility treatments. Oh, and she only sent that to me because she's being respectful, but I thought she was putting it in the chat. Katie, it's okay for you to answer these questions in the chat for everybody to see, because I can't know everything, and thank goodness you're back there hunting down everything for me. It just makes it a better presentation for everybody, which is what we're here for. We're here to give you information. I'm not perfect. Those of you who work with me know this, like, and then some. But I do love my job, and I do love this area of the law, and I do love my practice. All right. So, PWFA, ADA, SCPAA, job modifications before, during, and after pregnancy. We've talked about those. And how to balance the essential functions that cannot be performed, with the admonishment that we need to be more lenient. Note that really undue hardship under this scenario, if you look through all of these and think about them in terms of legal compliance, it's really hard to meet. When I look at all of these together and knowing what I know about the EOC particularly, I feel like I deal with them at least once a week. You know, undue hardship is going to be a hard sell. And, you know, the EOC is more employee minded than courts are. But that means you're going to be relying on a jury to determine whether or not this was undue hardship. And even though jurors and juries are made up of employers, and employers are made up of individuals, most of the people on the jury have been employees but not employers, and so they tend to be jaded against employers. All of them have had something happen to them that they felt they were done wrong by their employer, and they just come into the jury room with that in their mind. I mean, they don't necessarily thoroughly analyze liability, as you might hope. Next slide. All right, now we're moving on to nursing mothers. It's 12:34. I feel like it's amazing that I'm now switching to another area of law in a timely fashion. But keep the questions coming. I think that I have kept up with them. All right, so the Pump Act. All right, this was passed December 29, 2022, when all of us were probably on Christmas break, or if we were not, we were at work and slammed, because otherwise we would be home on Christmas break, right? And which means that a lot of us just did not notice this. It was a bit of a shock to come back in January and peek around and realize, oh golly, this is significant. And it was effective immediately upon being inactive. It applies essentially to break time and space protections, and it extends what the law was already at the time in regards to those. The Department of Labor indicated 9 million employees who previously were not covered would be covered. So we're going to cover what that covers. Remember, the Department of Labor enforces the PUMP Act, investigates complaints, and the PUMP Act gives employees a private cause of action for any violations. That's also true of PWFA. So EOC does PUMP Act, Department of Labor. EOC does PWFA, Department of Labor does the PUMP Act. It's the Department of Labor's Wage and Hour Division. They also handle the FMLA investigations as well as the Wage and Hour investigations. And they too are very employee oriented. Next slide. So here is the DOL guidance. So one of the things happened when the PUMP Act came out, we all said, well, we need to find out, what this guidance is going to tell us, because some of the language in the PUMP Act was pretty disconcerting. I specifically had a client who had a situation that had arisen in December, and then a claim came in from an employee who was no longer employed there in January. And the lawyer that wrote the letter was making a demand on the basis of protections in regards to lactation and PUMP Act. And it was a scary, scary thing, because the PUMP Act specifically requires that every single time an employee who's lactating needs to take a break to express, you have got to grant it. All right, so that is just unequivocal every single time. And this particular employer, that was difficult for, right? And I can see a lot of employers that this would be difficult for. Some not, but many, yes. And so I thought, well, every time seems like a lot. Well, I've changed my thinking about it simply because I had to, right? Because it's what the law says. And when the Department of Labor came out with this, it specifically also said every single time. So that's the law. But then I thought about it in an organic way, and I thought, well, when someone's got a pump, they've got a pump, So, we all somewhat understand this. I understand it somewhat. I was in a situation where, I wasn't doing that after I returned to work. I'm just old school gal. I actually returned to work, y'all, after 6 weeks. And my first day back at work, I tried a 2-week trial. It was not at this firm. It was way back in the dark ages when there was no FMLA, and you did take 6 weeks, and that was what you got. So, I only have experience with that short period of time and don't really recollect. But in truth, I think it does make sense that these employees, when they need a break, and a lot of these folks that might be on this training can echo this, that when they need to go express, no, they just need to, right? So that makes a ton of sense to me as a practical matter. All right, so that's what it's going to be. And if you look at every single one of these things that are in italicized lettering here, I just dropped it right from the guidance into this PowerPoint so that you would know this is some pretty stringent guidance, and it will take a big change on how many employers might be doing things now, because you have production requirements, you have people that need to be, client facing, patient facing. A lot of folks can just express in their office and continue to work, but a lot of employees can't. And so this is going to be a departure from a number of things. This can impact production. This can impact hours worked, as far as how much someone's actually working. All right, and we'll talk to you about that, because the Department of Labor says you can't not count this stuff as hours worked, but we'll talk about that. But as far as who's actually doing the work and what is required. And so we're looking at jobs that we're fitting in an 8-hour day. And if only 6 hours can get applied to that job by the employee who is protected by this act, then that's the way it is. And we cannot require them to work after or outside of their schedule. All right, so let's talk about what this looks like when you're meeting with an employee. The employees come back from maternity leave, and they need 1 year to engage in the expressing of the milk while they're working. And you can reach an agreement with them. You can, but this is what this looks like. You say, how often do you think you're going to need? And the employee will tell you, and you'll say, all right, I want to just document it so that we have it. But if you think you need more or there's a change, I need to know. Because as you can see, we can agree on a break schedule, but we can't require the employee to adhere to that schedule. And the agreed upon schedule can be adjusted over time, right? So an employee may need more times for breaking to express, or as time goes on, they may need less. So this is something that's fluid and needs to be evaluated on a case-by-case basis and as during the time period. And you need to encourage the employee, and you want that to be in a way that if you're documenting, that also says it. You encourage the employee that you can come back and let you know if you need more. Next slide. Examples of reasonable break times. I thought I would drop this here too, because I spoke on this last week, and I had some folks in the room who were not HR folks who were very, very upset about this, and some HR folks that were very, very upset about this. So I added these examples from the Department of Labor on purpose. Irina, a shift manager at a fast food restaurant, takes 25-minute breaks each day when she returns to work after the birth of her child. The DOL's wage and hour division says that's a reasonable break. Leslie, at a department store delivery driver with a 9-month-old baby, needs 2 30-minute pump breaks each day she works. That's reasonable, right? And so these time periods are not limited to your normal break times. And I think you probably knew that. But I think what's important is that these time periods are as long as it takes for the employee. That's what guides it. So we don't tell them how long these breaks take. They tell us, and we honor that. All right, next slide. Okay. Now we're going to talk about compensation. We're talking about length of time for the break. We're going to shift gears to, do we pay them for these breaks? The Fair Labor Standards Act and the Affordable Care Act, working together, already required you to pay an employee who is expressing milk the same length of time that you would pay other employees when they're taking breaks. Okay, they've already that's already been a rule. Of course, if someone is not completely relieved from duty, we're not making them clock out. They're still working. Some people can express while they're working. Right, so we're not talking about them. We're talking about the folks that are in a job that does not permit them to express while they're working. So they've gone on break. We require everybody to clock out or not. If we don't require people who are going on breaks to clock out for breaks, do not require it for these pregnant employees. If you pay other people for paid breaks in the day, you have to pay the pregnant worker the same length of time that you pay the others. An example would be you allow breaks, paid breaks, 2 breaks a day, 15 minutes apiece. The employee is somebody, let's say it's Irina, she takes 25-minute breaks. Irina needs to be paid for 15 of the 25 minutes, which means you're going to have to come up with a way to track that, to track the break time. And there's a bunch of different options that you can discuss. I always like options that involve the employee telling you what the break time was, because then they can't contend later that they didn't do that. That, of course, has situations that are ripe for abuse. Some of the things that were thrown out last week was, well, do we have them we pay employees for 15 minutes. We don't require them to clock out. You know, do we have them clock in and clock out after the remainder of that? I don't know, that seems a little arduous, but that is up to the employer. Time records do have to be complete. I typically say, you know, if people are on break, think about having them clock out so that you can always keep up with that, or some way to keep up with that, so that if there's a dispute later, that's going to also be true of the employee that's pregnant. But how do you deal with that logistically? Because if these are paid breaks, then you probably don't have payroll being alerted. These are just time records, and it's not necessarily triggering payroll. So I'm not going to waste too much time. It's already 12:45, going down some rabbit hole on that, but it is something that has to be thought through. So this employee who is needing a paid break, this is an example from the DOL. who uses the break time to pump breast milk must be compensated in the same way other employees are compensated for break time. And this was pulled right from the DOL's FAQs. Madison works on a farm, and her employer provides all employees with two 15-minute rest breaks each day. She chooses to use both of her paid 15-minute breaks to pump for her 6-month-old infant. She needs additional breaks to pump. You do not have to pay the 15 minutes for the additional break, as long as she does not perform any work during the breaks. So if you only pay for two 15-minute breaks, that's all you have to pay for the mother who is expressing is two 15-minute breaks. You have to let them take the length of breaks that they need, the time that they take, and as many as they need. That is something you're going to have to train your boots on the ground people, or they're going to be telling your pregnant workers, your nursing mothers that they are only allowed to take two 15-minute breaks. So this is really, really important to train your boots on the ground. Next slide. All right. The Department of Labor's guidance on the Pump Act compensation is this: short breaks of 20 minutes or less should be included as hours worked. So, just like you would include breaks of 15 minutes or less as hours worked for your non-lactating workers, the Department of Labor says 20 minutes or less. The Department of Labor says it. The Department of Labor enforces this act. It's not worth it, in my opinion, to challenge it. Okay, I think the rest of the stuff I've already covered. Here's some more questions. Does the employer need to provide resources such as pump containers or refrigerator? No. We'll talk about that in a little bit. We'll talk about what you're required to provide, and then, of course, whatever you want to do is on top of it. Does an employer need to allow employees to come in late in order to pump? I think that's an interesting question, and it would depend on the job and the employer and the employee. I think that's an interesting question. I do think that that could be a reasonable accommodation. Can employer request leave to leave premises to deliver milk to child? I think that's interesting. You said can. I think you can agree on any accommodation you want. The law does not require that they be allowed to leave premises. Next slide. All right, so space requirements. Let's talk about the space requirements. What do you have to do? So the Fair Labor Standards Act already required, and the ACA, the Affordable Care Act, already required us to give nursing employees access to a place where they could pump at work that is shielded from view, free from intrusion from coworkers and the public, available at any time the employee needs it, and not a bathroom, right? And so free from intrusion means, ideally lockable, or that, for instance, our office you can see through the very top window by my door. You cannot see through the frosted one that's about average, that's the size of somebody who's about 5'10". Some people that are tall enough look over into the glass that you can see through. And we have great attorneys who are here expressing while they're working. That's a problem. That if that happens, then we got a problem. We have violated free from intrusion from coworkers. So stuff to keep in mind. What is free from intrusion? And we'll talk about spaces. There's all kinds of examples of spaces all over the place, and I've provided my clients those, and I can provide it if you don't have a space in mind already. You don't have to have this space just sitting there and ready for use whenever anybody needs it. Your duty to provide this space comes up when it is needed for the specific employee. And you can even change that for different employees, but not for the same employee. Once it's provided, it's provided. Another instance I had was where the space was actually somebody else's office, and that that employee would depart. It was a manager, and that employee that was needing the space to express would then come in. But my concern with that is that required this employee to come and ask the manager, may I use the space? I think that's not ideal. So if we are working out the schedule, this can help us prepare that manager to exit the room in a way that does not interfere with the employee's need to enter it. It's tough. This is tough. So that if you're having someone use an office that's already somebody else's, you're going to need to take some extra precautions so that the employee isn't feeling like harassed or isn't feeling uncomfortable. Anything you can do to make this a little smoother would be better. All right, so again, temporary space is fine if it's meeting these requirements and available when the employee needs it. So temporary, we've even seen little partitions. I think, if you go and get a flu shot now at the drugstores, or even in the Publix, I think I got a COVID shot in the Publix. They just put up these little screens and I'm shielded from view. So that's suitable. That's one of the examples that is provided in the documents outlining space requirements for compliance with these laws. Next slide. All right, privacy. Ensure the privacy. Display a sign. Obviously, if teleworking free from video view. Look, that means you don't require the employee to be on video. Presumably, the employee knows if they're on Zoom while they're expressing that they should be off video and possibly off audio. Functional space. What is a functional space? The Department of Labor says it's a place to sit, a flat surface other than the floor to place the pump and for the safe storage of the milk, such as an insulated food container, personal cooler, or refrigerator. Also, it ideally has access to electricity for the electric pump and the sink to wash hands. So ideally does not mean required. What is required is what we already outlined. And the employee needs to be able to sit. And the employee can put the pump on a level space. A lot of employees have pumps that can be charged and they don't need to be able to plug them in. And they also have insulated containers already ready. Some employers have specific refrigerators, in the room that they have set up for this purpose. Some employers have wellness rooms where they have a small refrigerator. They have a nice little chair that can be turned into a cot, and that also has a sink. That's fabulous. And that's used for a number of things. You could put a sign up and lock it if it's for the lactating, the nursing mother, or for someone who's needing a nap down there. But if it's getting used by a bunch of folks, remember we've got to make sure that it's accessible if we've got somebody who we're complying with Pump Act requirements and somebody who's needing to express. So these things aren't required, the sink, the electricity, the refrigerator, but the Department of Labor says that's nice. Next slide. So ideas from the DOL, here are some examples, all right? Storage rooms, at one point when the ACA came out, everybody was like, storage rooms, and then the ACA or whoever, I can't remember who said this was back in 2012. No, that's not okay. Storage rooms that are dark and, don't do it in the broom closet and stuff like that. So, pick a storage room that has some light and that is not freaky and smelly. Pick a good storage room. Next slide. All right, there's an exception to this law, and it's the small employer exemption. So small employers who meet these requirements can be exempt. If they can comply, great. But if they need to be exempt, they can be exempt. Under 50 employees, and this applies to an employer who has under 50 employees. It did not define, to my recollection, Katie, maybe you can pick full-time or part-time. Some laws require us to count our part-time employees for full-time equivalents. Some laws don't. I suspect, well, I have no idea. I'm not going to guess. Katie's going to find out for us and put it in the chat. And it also applies to small employers in transportation. You count all employees, regardless of work site location. And then this is what you have to show in order to say we need the exemption. It has to be on an individual employee basis. So this is not an exemption that just applies once you've established that you meet the small employer requirements. You bear the burden, the employer, and you've got to show the specific need for pumping at work creates an undue hardship due to difficulty, expense in light of size, financial resources, nature, and structure of employer's business, which is obviously specific to your business, and then specific to the employee and the employee's position. Significant difficulty or expense is what's required according to the Department of Labor guidance because you only have to do it for a year. So you're seeing that same language of, hey, this is only 40 weeks from PWFA, and you're seeing it again here. It's only for 1 year, so if you're going to claim this exemption, it's more than just undue hardship because it's only for 1 year. And this exemption applies to the space and time requirements. All right, it does not apply to the paid bill. So keep that in mind. Next slide. All right, the Lactation Support Act. This is less stringent than the Pump Act. Y'all already knew about it, so I'm really not going to spend any time on it. You've got slides. Next slide. Similarities and differences. All of them require break times paid. Yeah, go ahead, Brittany. We can slide on because I want to just touch on a couple of things in these last couple of minutes. And I think we've got all the questions. I think I've got all the questions. So, medical leave requests or any type of leave request like what we talk about under any of these laws, and also the Pump Act, which is not a medical request, but this is the stuff of nightmares for human resource compliance, and y'all know it. You don't need me telling you. And so often you call me because something has happened and your boots on the ground supervisor has already done something, said something. This navigating all of these continues to be the hardest thing about human resource compliance, in my opinion, and even for the most experienced human resource directors. The most experienced ones are the ones I'm on the phone with and I'm helping work out how we're going to deal with it. I spent a good hour on the phone with one today navigating this, and it just implicated the FMLA, the ADA, and workers' comp. I mean, it's a thing, right? And it's a step-by-step basis. So next slide. In regards to pregnancy leave and how those interact with the FMLA and ADA, follow your company policy. And then look at how you can change what you're offering outside of that company policy as it's associated with pregnancy and childbirth. So FMLA, and then we've already talked about PWFA and POC, so I'm not going to get into that here. And then you add in FMLA. Remember, FMLA, pregnancy leave is protected under FMLA. Medical conditions associated with pregnancy, protected. Serious health conditions, and that includes mental or physical, all protected. They're also protected by the ADA. FMLA applies to adopted situations. See, postpartum depression, medical conditions. So all of these laws are implicated, and whenever you're approaching something, don't just stop at the PWFA, although the PWFA is pretty comprehensive, isn't it? But thinking also about FMLA, because we didn't talk about, the FMLA 12 weeks job protected leave. All of these things work together. We've got to always look at them in a big old bucket together. Next slide. So in any pregnancy leave, if an employee qualifies for FMLA and you are an FMLA employer, they're going to get 12 weeks job protected leave. After that, they're going to have to either continue to get leave or some sort of job modification if they're ready to return to work for as long as they need it, absent undue hardship. Next slide. Train your supervisors. And this is where I wanted to get, and I've got a couple of slides about how you do that. But train them on what triggers it. Train them that if anything comes up about pregnancy, medical leave, or disability, or accommodations, or I'm going to have a little outpatient surgery, or I'm going to be out one day because, HR. Because once we get it in your hands, we can almost, resolve any sort of issues that are going to come up with the supervisors attempting to do the right thing and not knowing the law because this isn't their job. All right, next slide. These are some things you can use to train your supervisors. All right, how can I help you? Listen and say, hey, I want to make sure we're getting HR involved. And then they don't need to make any comments. They don't need to inquire about the condition. They don't need to say things like that doesn't seem like it's something we can do, or this doesn't even seem like it's something you can't do. None of that, and get right to you. Next slide. On this slide, I talk about the human resource role. Train them, and then get involved. Don't let them be handling anything after the part where somebody tells them, one of the things that triggers those areas. That does not come to good. And even if you allow them to stay involved in the conversation, I want y'all present because you know what needs to be documented and you know what's compliance. This tells you what you're doing next. You know, somebody wants any sort of change of how things are done. I always recommend verifying the condition. I already said that. And that's where, instead of just taking their word for it, every single time, say, go get your treatment provider to tell me what those are. Pop back in. After that comes back and you decide, okay, I'm looking at what your treatment provider says that you need as an accommodation and your restrictions. I'm looking at your job and I'm the one that decides, me and the supervisor, or can we accommodate? Next slide, and then I'm going to shut it down and answer that last question. I think I've covered that. Next slide. All right, so then from here on down, you've got FMLA and ADA refreshers. And so I didn't really intend to cover that today, but I wanted you to have all of that stuff. So additional questions. Adoptive fathers could also potentially claim postpartum depression under PWFA. I don't think so. I think FMLA. PWFA is for pregnant workers. So no, but I think they might be protected under FMLA. Assuming they were able to provide medical certification. If they're not eligible for FMLA, then ADA, assuming they were able to provide medical documentation. Next question. Caregivers of pregnant women only covered under FMLA, correct? No mention in PWFA. Correct. I think that's an interesting question, Raquel, and it's 101, and I might email you later if I think of something different. But no, caregivers, yes, I'm sorry. Yes, Raquel, you're right. FMLA is what covers caregivers for pregnant workers. Obviously need a sip of water, possibly a cup of coffee, and a breather. This has been lots of fun. It's always fun to present with y'all when y'all ask me a million questions. And apparently Katie was not able to answer the question that we threw out. And so I know Brittany will remind me of what that is, and we will get the answer out when we send you out these slides. I'm always appreciative of everybody that comes. Thank you for coming. She says adoptive mothers can potentially claim postpartum under PWFA. Correct. But adoptive fathers, I don't think so. I think they have to be under FMLA. And I think you're making a really good point, Stephanie. Maybe it all should be under FMLA. Good question. I think I've just discriminated against the genders up in here. So it's probably time to shut it down. Great question. So everybody and Stephanie, y'all have a great day, and thanks for laughing. And come see Katie next time. I'm gonna do her research for her if there's any questions she doesn't know, but she won't not know any. Y'all have a good day.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.